Hello, my name is Shrees. I'm an attorney in Virginia. Frequently in my practice, we handle divorce cases wherein one of the parties wants to file a divorce based on fault, or my client is being accused of fault. So, what is a fault-based divorce in Virginia? First and foremost, you need to understand what exactly does fault mean in a divorce. Because the fact that somebody just said some bad words to you or they were mean to you does not mean that you're going to get a divorce based on fault-based grounds. There's a certain number of grounds that are specifically enumerated in the Virginia Code that talks about what is fault. And if you don't meet that criteria, then you cannot file for a divorce based on fault. So, to have a fault-based divorce in Virginia, you have to have grounds. The grounds are the following: adultery, a felony conviction, desertion, cruelty, abandonment. Those are the grounds for filing for a fault-based divorce. So what exactly is adultery? The dictionary defines adultery as voluntary sexual intercourse between a married person and a person who is not their spouse. If you want to seek a divorce based on adultery, you have to prove that the spouse has had or is having a sexual relationship with another. A felony conviction. If the spouse has been convicted for a felony and is sentenced to jail, that may be grounds for a divorce based on fault. Cruelty. This is a really broad term. In most cases, it will be the use of violence, the threat of violence, and fear. When you make this allegation, you have to be able to prove that there is a reasonable fear of your spouse causing physical injury. The relationship between the spouses should affect both the mental and physical welfare. There may be several acts of cruelty that would snowball into a larger issue, leading to a divorce. In extreme cases, the court may consider a single act of cruelty enough for divorce. Desertion. This means one of the spouses has abandoned the marriage with no justifiable reason. The intention to desert the marriage by the spouse must be permanent. To establish desertion, you have to prove that the deserting spouse plans to end the marriage, that the deserting spouse had no justifiable reason to desert the marriage, that the desertion was against the wishes of the other spouse. Keep in mind, you cannot allege desertion if you had a mutual agreement that you two were going to separate. Deserting means leaving the marital home and will result in a property division, alimony, and custody rights that may or may not go in your favor. Now keep in mind that you have to have proof for all these grounds. Any of these grounds must be supported by evidence. Usually, in most divorce cases, that is through a family member or a friend who knows about the problems between the husband and wife. And that can be whether it be adultery. In terms of an adultery, you can get that from a detective potentially. You must have information and witnesses to corroborate your testimony. Just coming to court and saying somebody did something mean to me is not going to be enough for the court. The court has got to have corroborating information. Now, you can also get a divorce that is not fault-based, based on a separation for 1 year or more. Keep in mind that if you're filing for divorce based on fault, no waiting period is required. And the court does have the authority to grant a divorce immediately. Now that rarely happens. Now, for a divorce based on separation, the spouses must live separate and apart for a period of 1 year. In the event that there are no minor children in the marriage, then the time period can be shortened to 6 months, provided you have a property settlement agreement that resolves all the issues between you and your spouse. If you're thinking of filing for a fault-based divorce in Virginia, contact my office at 888-437-7747. Again, my phone number is 888-437-7747. Thank you.